Okay, so I'll start now. Today we will be presenting the critical analysis of media freedom laws. Our members are Jasmine, Gabrielle, Khoo, Bhavan, and Ashraqal Haziq. So for the introduction, it has been a huge debate whether the public has the right to receive every single information or should the government control what is informed to the public. So we will be discussing 5 laws that have something to do with freedom of information, which is Sedition Act 1948, Official Secret Act 1972, Printing Presses and Publication Act 1984, Communication Multimedia Act 1998, Copyright Act 1987, and we will be discussing what changes can be done to make sure the law is up to date with the evolution of media over the years. So now I'll pass to Bhavan to explain on the Sedition Act.
Greetings. So I'll be talking about Sedition Act 1948. So I think when we look at the background of the Sedition Act 1948, this law basically teaches that it prosecutes anyone such as illustrators, human rights defenders, authorities for expressing their thoughts of their government, royalty, and religions. Because the government, royalty, and religions are considered sensitive in Malaysia, and they have been given a very high priority, and it limits speech which are seem rebellious. It could trigger issues such as racism, because one sensitive issue, it can trigger the whole nation in the country, and then racism will occur. So criticism from this Sedition Act, it limits the people from voicing out their opinions, because people are scared whether if they voice out their opinions, some people might take it too sensitive, some people might take it a light way, and an argument which can occur. So to propose changes, here are some suggestions that I propose. People should be given more chances to voice out their opinion instead of keeping it to themselves. We can voice out our opinions, but given that it shouldn't cross the limit. As long as it doesn't cross the border and it doesn't hurt anyone's feeling, it should be fine. And constructive criticism should be allowed, since it will progress better for the country. Right now, Official Secrets Act.
Hi, I'm Gabrielle. I'll be presenting the Official Secrets Act. The Official Secrets Act 1972 was created to protect and preserve any legal and private information within the government. Other than that, anyone that spreads or leaks any government information will be charged under this law. The OSA definition of an official secret is any document of the Cabinet, State Executive Council, and documents that concern national security, defense, and international relations. This act has received numerous criticisms since it was enacted, as it limits the citizens' freedom of getting information and prevents the public from knowing information that will affect them. Next slide. An example of how the OSA has gone against the freedom of speech is when Sabri Sharif, a Malaysian journalist, was charged and convicted under the OSA in 1985 for having classified documents. He revealed discrepancies in the use of public funds in hope that there would be an investigation, but instead of investigating the discrepancies, the document was classified as an official document. Next slide. The main idea I would propose is to implement regulations that will prevent government officials from making any document an official secret without any proof that it is to protect the national security, and not just for their own benefit. Another idea is to form a jury of reputable senior lawyers to debate on whether the document that is supposed to be an official secret is justifiable. The next thing I want to point out is that there should be proof before arrest, as there is a part where under OSA people can be arrested without any warrant, and it has been abused so many times. For example, the arrest of Yusaini Ali, a reporter that wrote on the kidnapping and murder of a Malaysian industrialist's 14-year-old son. Even though they did not have enough evidence, they still locked him up for 5 days. Next, I would pass to Haziq.
Thank you, Gabrielle. So now I will explain on the Printing Presses and the Publications Act 1984. The background of this PPPA Act also was developed in 1984 to govern the usage of printing presses and the printing of art and other publication methods. A person can only use printing press if he has been granted a license under subsection 3. If found producing any document or publication that is obscene, against public decency, and contain any incitement to violence, and or show disobedience to the law and to any law order, then that person shall be found guilty of an offence under the PPPA. Next slide. In September 2017, 22 publications were banned, including 3 books from the Islamic Renaissance Front, also known as the IRF, charged under the Printing Publications Act 1984, publishing content that was considered regressive. There was an appeal from the IRF, but it was overruled by the High Court. Next slide. So the proposed changes that I would like to point out is to provide a screening process and who is able to make a decision on publications, on which publications are allowed to be published, reform the whole PPPA as it has been over 30 years since the Act has been revised. This is the reason because media is constantly evolving, hence the law to control media should also have some evolution to it. So now I'll pass to Jasmine to explain on the Communication and Multimedia Act.
Okay, thanks, Haziq. So next slide. Communication and Multimedia Act 1988, which is also known as CMA, is established to provide a set of regulatory provisions to regulate the communications and multimedia industry. So I'll be focusing on Section 233 in this assignment. So under Section 233, it states that any person who makes or creates of any comments, requests, or other communications through network service or network platform which are offensive, obscene, false, or any others that harass someone is committed an offense and shall be sentenced into imprisonment for not exceeding 1 year or a maximum fine of 50,000 or both. So next slide. So one of the case study that I choose to relate is in 2015, Datuk Zaid Ibrahim was accused of posting an offensive blog towards the previous Prime Minister, Datuk Seri Najib Razak. He actually urged Malaysians to support to remove the Prime Minister. The appellants claim that the statements contain intention to hurt others' feelings. However, the accused has been acquitted as there is no evidence to show that the appellant is annoyed or being hurt. So according to this case, the proposed changes to CMA Act would be to tighten up the scope of the provisions to prevent any abuse of using authority to make or create any comments that are offensive, and introduce more provisions in disseminating information or content. The aim of the changes is to prevent any parties to provoke with intention to harm another parties. Also, to avoid any information that is misguided or creates fear or annoyance from being disseminated to the public. And nowadays, the information will spread immediately, and it is necessary to create a clear and fair restrictions and limitations. Next slide. So continue with the Copyright Act. Copyright Act is a right that is granted to the author of their original work to prevent anyone from copying and make it as their own work. So under Section 13, subsection 1, it outlines the scope of protections for the author for their works. For instance, literary works, musical works, artistic works, film, sound recordings, and broadcasts shall be the exclusive right to control in Malaysia. The owner of the work should prepare the appropriate documents to prove ownership so as to establish ownership of any copyrightable work in Malaysia. Okay. The proposed change of this act in is adding provisions in regulating some restrictions to follow up on the digital millennium today. For instance, like internet. As you can see, some music or songs has been recorded on YouTube and publish it to their own channel to gain viewers and likes. It's actually an offense, like under this Copyright Act. And also changes could be made in adding provisions for copying someone's idea or any artistic work is the owner could provide any evidence that the idea is from him or her. Under Section 7, Subsection 2A of the Copyright Act, the protection excluded the ideas, procedures, methods of operation, and mathematical concepts. It will be an issue as the idea is not under the protection, even if it is the original piece. There's a case in which the plaintiff failed to show the evidence that the artistic work is his creation, and it is actually his original work. So the High Court eventually dismissed the case. So that's the end for our presentation.